I think the first presenter that I wanted to follow up with is Mr. Lino from Argentina, and I think one of the very interesting issues that he discussed was one that was brought up yesterday by a number of panelists and also those of you who are participating in the audience. And one, I think, very good question was whether or not you need an independent organization providing legal aid services. And Mr. Lino talked a little bit about functional independence, which is actually what's discussed in the principles and guidelines. And I wonder if you could just comment, elaborate a little bit on what you see as the key ways in which you are able to maintain independence of the public defense function from the state, given that you are a state agency, and in fact the public defender is appointed by the state.
Yes. Well, as I told in my presentation, our independence is warranted by the Constitution, and I think it has two main aspects. One very important aspect is the one of financial autarky. I mean, that we prepare our own budget. It can sound very utilitarist, but it's important, because if you manage your own money and you can prepare a draft budget that is usually approved without problems. Our budget is sent to Congress together with the Prosecutor General, I mean the one for the prosecutors, but it's in divided pieces. The General Prosecutor and the General Defender send them together to the Congress with what they think will be paid, or I don't know, the expense every year, and then they send it to the Congress. So that's the first important thing, and then the important thing of having a head institution, the General Defender, and that's also related to quality service, because I didn't say it in my intervention, but apart from the exams we have to give to access to be a public defender, which also ensures quality, and the payment, that is also a competitive payment, so we can make a career. I mean, in my case, I went to university, made my post-degree, and I could be a private lawyer, and I can be a public defender. It's a career you can make, being a public defender. And as we are well paid, equally to judges and prosecutors, it's an option. And if you, and that's also brings to the institution a lot of people that are ideologically like defend. I like to defend. I couldn't do anything. I couldn't accuse someone. So I go to the institution. So I think that's very important. And the General Defender also gives us some instructions. Then there we are not independent in some from our General Defender, but she gives instructions all in order to guarantee a quality service. So, for example, if there is a law which says that in a second crime or a third crime you can have, like, similar to 3 strikes in the United States, then she passed a resolution with international arguments saying all public defenders must say to the court it's unconstitutional and take it to the Supreme Court. So then we start to build standards. That's an example, but I can give a lot of examples where we receive from our General Defender instructions to we are free to having our own defense strategy. She won't interfere in that. But then in certain things, certain aspects, which would be against international standards, we are obligated, it's mandatory to ask for the court to declare it constitutional, etc.
And just following up on the question of budget, you talked about how one of the key ways that you maintain independence is by having an independent budget. And I think one of the things that all countries struggle with is what should the budget be for legal aid? And how would you determine that? You mentioned a little bit about your role. I wonder if you could elaborate on how exactly you make a determination on what your budget should be, and then how you advocate that to the state.
Well, the General Administrator of the institution has got like a very huge job with the Ministry of Justice in order to demonstrate each year what would be our needs. It's not that the Ministry of Justice is going to determine it, but as the money comes from the executive power, that's the most, let's say the money comes from the tax payment, etc., from the general budget. So we have to demonstrate what are our obligations during the year, especially the salaries, the payment for the public defenders and all the employees of the public defender offices. And then all the money, sometimes we have assistance for paying bails, small bails, and then they have to negotiate in some way, in the good way of negotiating, because usually there is no problem, and then they establish a number. Our numbers are usually half of the money that use the prosecutor office, because there are a bit more prosecutors, and they have other obligations in the organic law, so they need more money. But with the money we're receiving half every year around from the prosecutors, it's enough for paying the salaries and all the buying. We have our own buildings, etc. And then usually the government doesn't make, even in crisis time that we're always with different kind of crises, and they don't make an issue of the thing of money, because I think government, since the constitution was amended and the public defender office was declared independent and autonomous with financial autarky, it was like a political decision, and the government, I think, being intelligent in this point, they decided that it's not justified that if you have money to pay judges and to pay for prosecutors, you don't have money to pay for defenders, because it's so important, the defender in a controversial system, a defender as a prosecutor of a judge, so there is no justifying for spending less money in public defenders, because it guarantees a quality justice, criminal justice system.
Mr. James, you talked a little bit about the role of standards in your office, and particularly related to caseloads. And I know that there are probably hundreds of thousands of people that are arrested every year in New York City. You have a limited number of lawyers, and I wonder if you could talk a little bit about the role of those standards, how you as an institution, kind of ensure that your lawyers are not handling too many cases, and at the same time, with the number of cases they're handling, and maybe you could talk about that, how you ensure that they're still providing quality representation.
So I should preface my remarks by saying that some years ago, we actually had contracts with the city which required us to handle all the cases that came in when we were assigned to arraignments. And that created a situation where the staff was not able to provide the highest quality representation. There was much triage going on. People attempted to prioritize which cases to handle, and many clients were not getting the best possible representation. The recent contracts with the city now have a set number of cases for which we are paid. If we exceed that number of cases, we get additional funds so that we can handle hire additional staff. There is an overflow. There are other providers in the city who handle matters, and also there is an assigned counsel system. But as I said, there was a time when we handled everything that came in. We made a determination that in the long run, it was better for clients that we not handle everything, but really focus on providing quality representation to those cases where we could actually give the best possible service. So it really comes down to letting the city know what the number is and how many you can handle, and not forcing attorneys to handle 110, 120 cases at a given time. So they're not able to meet with clients, they're not able to do the motions, they're not able to prepare adequately for their trials, and not able to send out investigators on all the cases that they have.
And just going to that issue of investigators, you talked about the role of investigators and other support staff in your office. I wonder if you could talk a little bit more about their relationship with the lawyers and how that enhances the services that the lawyers are providing.
So the investigators and the social workers really work in teamwork with lawyers. These are functions that have to be completed, and if we don't have investigators engaging in looking for witnesses, then the lawyers are going to have to do it. And if they're doing it, then they're detracting from the time that they would spend actually doing legal work. We have found that fact investigation is probably the most important aspect of preparation. You you need to know what the witnesses say. You need to know whether there are witnesses which will contradict the complaining witnesses. And you also can find out exculpatory witnesses. Without the investigators, the lawyers are not able to get this information and are not able to properly advise their clients. In the same way, social workers provide alternatives to incarceration. They find information to mitigate the offenses so that they lessen the sentences and provide alternatives to incarceration, and also to get clients released on bail.
Mr. Vidaka, I think one of the interesting things about South Africa is that it was really a conscious decision to move to a mixed model approach here in this country. I wonder if you can say a little bit about how your country decided to move to that approach, given that many countries are trying to think about what is the best approach for them and how they would determine that.
I think it was an issue of continuous research, which informed in terms of how one can go about setting up a system that would deliver access to justice, increasing access to justice for many people. Continuous research, consultations, reviews, but also an issue of identifying the gaps and linking the strategic partners that can assist you in increasing access to justice, to close those partner gaps, and models and partners that can also work in understanding of your mandate and linking to all the objectives and your values to be able to deliver access to justice.
And just a follow-up question on how your system is structured. You have a board, a legal aid board, and this is something that I think a number of countries are interested in, wondering what would be the function of that board and how it relates to the actual provider in the system. I wonder if you could just talk about the relationship between the board and your justice centers.
The board of directors is established by the Act, Legal Aid Act. And I would say categorically two main functions, or should I say the main two roles of the board. They provide a strategic direction to the organization, to the executives who are running the operations within the organization, but also they provide or they play an oversight role in terms of how the organization is functioning, the financials, and ensuring that we deliver in line with the mandate and look at objectives. So those would be the key two roles that are played by the board of directors of the organization.
And my last question, you mentioned a lot about how you're able to work with the private bar, and you've developed a lot of linkages. And I wonder if you could just talk about, given I think a lot of the discussion yesterday about some of the challenges in getting buy-in from the private bar to legal aid systems, about how you accomplish that here in South Africa.
I think the private practitioners generally will formulate certain ideas around what the organizations that are intended to assist poor people want to do or intend to do, taking work away from them. So it does call for a lot of interaction and partnering with them, and also explaining your role and showing that you are not intending to provide or to cause any harm on their side. So it's the same situation with Legal Aid South Africa. It was an issue of an approach. So we adopted a positive approach towards interacting with the private sector or the private practitioners in terms of showing what our intentions were and ensuring that we have a continuous interaction with them. We take interest in their matters as well as developing the legal sector as such. So that has enabled us to find some sort of working relationship with the private practitioners. As I've indicated, we have signed a lot of agreements with the private practitioner and law societies in terms of working towards delivering access to justice. So that has worked very well for us as Legal Aid South Africa in this country. Thank you.
Mr. Zaharia, I wonder if you could talk about, and I'm interested in the role of the Legal Aid Board in your country, and particularly how it makes decisions on, you said, a number of lawyers on the budget of legal aid. And I wonder if you can talk about on what basis these decisions are made and what data, if any, it collects in order to make these decisions.
though the legal aid board is entitled to take the decisions, and especially it relates to normative decisions, not related to individual cases. So the decisions usually means a regulation on something which is published in official gazette, which means should be enforced by everyone. Concerning the mode of practical approach towards decision, it's very important. I could say exactly, I think there is no exception. All the decisions were taken consensually. Usually, if there is no agreement, then we postpone it. And it's important because after that, those people selected and delegated by different institutions, they should promote the same policy in their institutions. For example, if we take a decision to have an external monitoring of the activity of legal aid lawyers, this means the Bar Association should think exactly to take some actions, for example, to revise or to adopt some of the standards, professional standards, which we consider should be valid for all lawyers, including legal aid lawyers. Related to the budgetary issues, we approved a methodology on estimation of the costs for legal aid, which explains exactly how to calculate it, how to count the money necessary for next period of time. And based on that, we argument and use all kind of arguments for Minister of Justice, but especially for Minister of Finances. I have to mention, in our country, the Minister of Justice is presenting also the budget of prosecutors and the budget of the National Institute of Justice, except the Superior Council of Magistracy. So they have a huge role in promoting the budget in Parliament. And this is why I'm mentioning that we are happy that we have a separate budgetary line, and we put it together. We decide, okay, we need this amount of money, we argument, and they are promoting and presenting this in Parliament as the next steps. So there is a methodology. When speaking about the number of lawyers, I could not say it's a huge and complex methodology. It's easy. For example, if we allocate, because we have private lawyers or on contractual basis and public defenders. If we see that there is a lot of requests and we should involve too much private lawyers, then we decide to allocate a unit for public defenders. So it's more based on experience and not on methodology, so nothing sophisticated. And also, I have to mention that we try not to make difference, because public defenders are the same private lawyers, but with contract for a period of time, and having allocated a number of cases, a minimum number of cases per year. In our case, we have 60 cases per year. So each month they should take 5 cases. Some of them last longer, like 1 year. Some of them less. For example, in juvenile cases, when we speak about diversion, there is only 2 meetings. So case finished. It depends on. But this is also, we should consider this a compensation, because internally in the public defender's office, they know exactly that the decision to whom allocate the case is not taken by territorial office for public defender. It's a case for public defender. After that, the manager of public defender office decides whom to go to that case. So.
Okay. And my last question before we open it up to the floor. You talked about how, I think, you mentioned it was relatively easy in your country to move to this new system. I think a lot of countries face challenges, and there are vested interests certainly in whatever system does exist. If it's an assigned counsel system, as you call an ex officio system, the lawyers themselves who are paid or the Bar Association may not want the system to change. And I wonder if you can just talk about how that process happened, whether there was any opposition and how that was overcome.
Maybe I was too optimistic saying it was easy, because now it's easy to speak about how it was. But in fact, it was, how to say, easy when you have a lot of partners, well-intended partners. And the main partners was the NGO sector and international development partners. I could not say about, for example, politicians supporting, because here is a discussable approach, how to involve with politicians in that process. So we excluded this idea and included from the first stage of discussion of any kind of initiatives, also Superior Council of Magistracy, especially then less prosecutors, because they are not interested in highly qualified legal aid. They are interested to have only the signature and presence of lawyer, just formalistic to be sure that procedural they respect something. Involvement from the first stage of any initiatives, it's important, I think, and also involvement of all partners, potential, like, as I mentioned, Service Foundation, but also UNDP, Organization for Security and Cooperation in Europe, so Council of Europe, and making contexts where the stakeholders could not say no. And also a lot of research, because a lot of now we speak about the low quality of ex officio, a lot of services provided by ex officio. Where do you know this? It should be data, and a lot of research was done for that from different perspectives. From the perspective of accessibility, level of payment, quality, comparing with private cases, comparing with standards that it should be. So when a simple argument, when you see the result of the final result of the Justice Act, someone being sentenced to 5 years, having a private lawyer, and with ex officio lawyers 7 years, using all data for all categories. For this category of case, it's easy to say, look, guys, something is wrong here.
Thank you. So we have about 25 minutes, and I hope that we can open it up to at least a couple of rounds of questions. We'll take a few questions and then have our speakers respond.
Thank you so much. My name is Dilraj Nimeri. I work at the Joint Secretary in the Ministry of Law and Justice, Nepal. And we have been highly delighted by the 4 panelists from 4 different jurisdictions. And a number of models have been described with some precision. And we see that in our jurisdiction also in Nepal, we have some mixed type of legal aid service delivery models, and perhaps to a large extent similar to those practiced or in practice in South Africa and to some extent in Moldova. And we have seen that any legal aid service is obviously need to address 3 things: availability, accessibility, and then affordability plus quality. And since, like a least developed country, Nepal, and where there is obviously a resource constraint, a number of challenges we are facing there. And the first challenge is how to coordinate these models. And second is how to harmonize the services or activities carried out by these models or mechanisms. And another challenge is how to streamline these activities into the national policy and program activities as well. So, in a nutshell, the problem we are facing now is related with the resource, related with time and the resource, and related with the efforts. And the deliberation by the panelists seems that there are some issues. For example, if we follow a single model, there may be some sort of overloading in that model, as mentioned by Moldova. And if we follow some mixed models, there may be some issues relating to duplication of efforts, time, and the resources, and the issue of coordination. Given all these factors in relation to the legal aid, I may request the respective panelists that what sort of mechanisms have been devised in their respective jurisdictions in order to address these challenges so that the models in operation in their respective jurisdiction can be replicated in other jurisdictions with some necessary modifications or some amendments. Thank you so much.
We have
Thank you, Madam Moderator. I do have 3 points to make. Some will be some observations or comments, and some will be questions. The first point that I'd like to raise concerns independence of legal aids. Here, in our experience of our study of various legal aid systems, well, we did hear about the independence of these legal aids. And we did also hear about the executive, giving the budget from the state budget matter. So here, the point here is that our study shows that there are 2 points in budget. One will be the functioning of the legal aid, the functioning of the services, and the other one is financial independence. As far as finance and budget is concerned, financial laws, at least in my country, whenever the financial year starts, we start with what we call the basic budget estimates. And that is promulgated into law called the budget law. Then in the middle of the year, if a ministry needs some more funds, it asks for supplementary budget. Then at the end of the year, when these are two combined together, the basic and the supplementary, we call the revised budget. So my point here is that our study also shows here that in certain countries for legal aid, well, it doesn't depend only on the state budget, but also it draws strength from even foreign investments that we have discovered. So my point here and my question is, how do you maintain independence from the executive if you are drawing from their budget in the financial sense? It's concerning finance. Well, that is my first question here. And the second point here is concerning the judicare. We have studied some countries in the Far East and in Asia that use judicare. And also we did learn that very soon in South Africa, there will be a mixed system of the study. So my humble question here is that, what are the advantages and disadvantages when you switch from judicare to mixed model? We shall be grateful to know. My third point is a comment to what has been said by Associate Attorney General, Mr. West, this morning, and also what Mr. James have said earlier on. It's a comment, actually. We do draw inspiration from you. We have studied your Declaration of Independence, your Constitution, and in particular, Constitutional 13th Amendment, where President Lincoln endeavored very hard and was successful. The 13th Amendment is abolishing slavery, if I'm correct. And then also your Bill of Rights. These are our great inspiration to us, and also of the Gideon case that has been mentioned this morning. And also your point, Mr. James, which you just said, about that no New Yorker shall be denied access to justice because of poverty. And if I may say so here, one great man said at one time that the greatness of a man does not depend in showing how he treats big men, but how he treats little men. So here, I would say that your New York jurisdiction shows exactly how you treat little men. Thank you.
Good morning, I'm Hadil Abdulaziz, Director of the Justice Center for Legal Aid, Jordan. I thank all the panelists for great presentations. I have questions that I would like to ask Mr. James and then Mr. Zaharia. Mr. James, thank you for your excellent presentation. And could you please elaborate on how in your systems you handle conflict of interest when you have several parties represented in the same case? And also, could you please advise on you mentioned your system for workload management. Who decides the weight of the case? Is it decided at the beginning of upon inception of the case, and can it be changed? Is it who takes care of all of the details? Do you take complexity factors of the case? Mr. Zaharia, first of all, I want to tell you that we were going to give you a wave for your presentation. Could you please tell me, describe in your system the percentage of civil and criminal cases? How do you prioritize? Your resources, for example, when you say you want to assign or resources to public defenders, but shouldn't that be impacted on by the number of cases that you are receiving? And if you need to prioritize, do you have resources for everybody, or if you need to prioritize, do you really give priority to criminal cases in your system?
Thank you, Jennifer. I just wanted to add to what Mr. Mdaga said to your question regarding the mixed model system. We've done research in this country, and we continuously do so, which showed us that judicare is expensive. It's 3 times more expensive in rendering services than we do through our salary lawyers in our justice centers. And that's based on the legal aid tariffs on which we pay private lawyers. So that's one of the benefits where we decided consciously to make little money go far, if you know what I mean. One question that I have is to Mr. James. He mentioned that the Legal Aid Society in New York also renders parole verification services. I'm interested to know how they do this. Do you wait for clients to contact you, or do you keep records of the people you've represented and start prompting them when you think they should start or initiate the parole process? Thank you, Jennifer.
Okay, maybe take one more and then we can, yes? Someone in the back here.
Hi, good morning. My name is Nushina Irfani, and I'm from the WITS Justice Project here in Johannesburg. We've been talking a lot about financial resources, but another capital for legal aid systems and boards is public opinion, good public opinion. So I'm interested to see what steps you take to build up that resource in your countries. Thank you.
Okay, that was a short question, so we can do one more.
I want to ask in Arabic language, okay? شكرا جينيفر، شكرا للمتحدثين. أود أن أسأل سؤال مباشر: كيفية التعامل مع شخص في موضوع العودة الجنائي أو تكرار العمل الجنائي من شخص واحد وتقديمه لعدة طلبات؟ شكرا. واضح؟
Thanks, Jennifer. I think it starts with the initial agreements you get to sign with different, should I say, cooperation partners, which will be your models. In terms of incorporation, all the principles you regard as important in ensuring the coordination around reporting, around quality issues, around the productivity and performance by all those models. And if you have been able to put those agreements in place, then it makes it easier for you to coordinate, because in terms of now analyzing the performance of all the models towards delivering towards a common goal, you use those basic principles and the agreements, and all models then align themselves in terms of all different categories according to what would have been agreed upon. But I must mention that in terms of the mixed model delivery, what appears to be important also is that you should have the main stronger model, which will enable you to control other models. Like in our case, we have the Justice Center model, which is very strong, and we are able to start a lot more processes from that model, and then we begin to link others around how the justice centers or the justice center model is delivering. So it does call for one strong model, and then you can coordinate others linking to the main one.
Did you want to say something on coordination?
So, firstly, about the coordination between stakeholders in the organizational system, but also about the providers. It's to mention that the aim of legal aid system, legal aid management in Moldova was not to include in the legal aid system all providers and to give them formalistic approach and standards and so on. If someone wants, like, for example, a private company to have their activities providing legal aid, it's their possibility to do it. But this doesn't mean we should consider it's already done there. We should look what's happening there, because we should ensure everywhere from the territorial point of view. For coordination of legal aid providers, the difficultiest part is involvement of NGO, because they are not permanent and sometimes supported by outside sources, which means we should count on them 1 year, 2 years, but we could have surprise at the middle of the project because they finished provide. So it's about informing. I could not say it's a formalistic or a well-established mechanism. There is a duty based on a cooperation agreement that they will inform about the fact that they will, as soon as possible, if they will not provide or if they will continue to provide assistance. But usually this is based more on the primary legal aid, because qualified legal aid in the Republic of Moldova is offered only by licensed lawyers. There is in court, no one without license could not represent someone, except some cases, but it's not legal representative, but more moral support. So the coordination itself is based on agreements. There is a general concept of cooperation of territorial office with NGO sector, which means different level of cooperation. For some, just distribution of materials like booklets, leaflets, and they provide materials for NGO to provide in different areas. For some of them, using the referral mechanism. For example, someone in need addressed to NGO, NGO will prepare all kinds of documents for benefiting of qualified legal aid, and the decision will be taken by territorial office.
Yes.
So, concerning the specific question about the proportion of legal aid in civil cases, legal aid in civil cases is provided from 2012, from 1st of January. The proportion is, I think, something like less 15% out of total number of cases. The increasing numbers is both from civil and from criminal cases, so the increasing number of beneficiaries. We had no chance to prioritize because it was established a separate budget line in our budget, specifically for criminal cases, for non-criminal cases, so we could take a decision to move resources from one part to another part, but it was not the case. We have savings for civil because the number of people which are aware of is limited, and coming to the public opinion and awareness, it's a huge program of awareness, like at national TV stations and local, once per week, saying, look, if you have different formats, but it's important that, to make people aware about the fact that they can ask and obtain this. But the biggest or the most efficient way of awareness is if from a specific village someone already benefited. So they are an informal awareness which works perfect. And it's about also of the level of trust.
That's good. Maybe we can move to the question of budget. Then we have a really important question.
If I didn't get the question wrong, correct me. Is the question from Myanmar is how do we maintain independence if we receive money from them? Was that the question?
That was, yeah, one part of the question.
Okay.
Yes.
I would answer to that. First of all, some important warranty in our case is that the financial authority is established in the constitution. So as many parts of our country, we have three branches, executive, legislative, and judiciary. They all have their budget, and the money comes from the executive. And the executive the Congress will always work because the executive always gives the money in the budget for the Congress, and also does so for the public ministry, for the defense office, and for the attorneys, and for the judiciary. If that wouldn't happen, it hasn't happened yet, but if they don't give enough money, if they say, I don't have money for you, we have a strong control, constitutional control by the judges, similar to the states. No, every judge can control. So we could make, based on the Article 120 of the Constitution, a constitutional action saying you are not giving me funds, give them to me, and a judge would order that because it's established on an article of the Constitution. And also, on second hand, our country has recognized the competence of Inter-American Commission and Inter-American Court of Human Rights. So we understand that if the government didn't give us money or not enough money to work and to develop a good defense service, we would make complaints on the international courts of human rights, and our country has declared that those sentences and declarations of the human rights courts organisms are mandatory to our country. So we are very controlled from upper side. So I think it would be difficult. It didn't happen probably because of that, because they have a lot of controls above. So it's difficult not, if they said, I don't give you any more money to develop a good defense system, for example, an independent system. So they haven't interfered with the budgetary autonomy in that sense. And probably I answered the one of public opinion that I was really interested on. Well, we are really unpopular because we defend criminals, so nobody likes us. My family, they don't like me because, yeah. But on the other hand, I think it's people knows it's an important service to give. I'm going to give you a very unpopular also example. I had a case last year that it was a very horrible rape, and a 16-year-old girl was murdered, and I had to defend that case. And look, they wanted to have a guilty person in prison, and the man who was in charge of the building, the man who was taking the custody, he was very poor. He was first taken into prison as suspect, no? So I had to defend him. And then there started to be, through the public opinion and the media that never helps here, the massive means of communication, they started to say that man was guilty, and I was defending him. So then we started to ask for the DNA, the proofs, etc. They were all favorable to us. Nobody, but the public opinion said they had destroyed that person because his face was all over. He was the criminal of Buenos Aires. And then public opinion was very important there. But then, and connecting it with the independence, there were pressures from government because they wanted a guilty person, because it was like the demonstration of ineffectiveness of the country to prevent crime, and you know how they use these cases. But this man wasn't really guilty. So finally, public opinion was against us here. But then, with the proofs, with scientific proofs, we demonstrated he wasn't guilty. And so sometimes public opinion can be, in specific cases, can be against us. But on the other hand, I think they know that we give an important service because it's all about a fair trial, so a fair justice. And on the other hand, another example, we are taking charge in Argentina, the Public Defense Office, Federal Public Defense Office, of the defense, not in my case in particular, but other public defenders, of the defense of, it's been opened all the trials against the violations of human rights in our dictatorship like 20 years ago. They are opening now all those cases, and the public defense they are taking the defense of former violators and of human rights, and nobody questions that. They know it's important because then finally the court the Supreme Court is gonna look how was that trial. It was a fair trial, and also the Inter-American Court could look at it. So the society, the government, everybody knows that a good defense service on those trials, as the other example I gave, is important.
Okay. And last to Mr. James, I wonder if you can just answer the second part of the question about judiciary services. Judge Malvo touched on the issue of research on the effective cost of these services, and I believe that there was a study in New York on quality, which maybe you can touch upon before going to the specific questions that were asked of you.
Right. The Criminal Justice Coordinator in New York City actually conducted an examination looking at quality, comparing the assigned counsel program to the institutional providers, the Legal Aid Society and other institutional providers. And they determined that the institutional providers were providing a better quality of service to their clients because they found that for those who were convicted, the sentences were lower, the cases were resolved more quickly, and the acquittal rate for the institutional providers, like Legal Aid Society, was better than for the assigned counsel. And in fact, the cost of assigned counsel was much greater. And they decided that previously, and I guess this will answer another question, it was asked, how do we handle conflicts of interest? We don't handle cases within our office where there's a conflict. Previously, they had been given to an assigned counsel plan. The city modified their plan so that other institutional providers will handle conflict cases, so that in each arraignment shift, which is when we pick up cases, there are two institutional providers, the Legal Aid Society and then another organization. And when we're the primary provider in that shift, we handle all the regular cases, and that other provider will handle the conflicts. And vice versa, when they're the primary, we will handle the conflicts. If there's a third person, then they will use an assigned counsel. Somebody from the assigned counsel plan to handle that case.
I think you had two more questions, one about the caseloads, who decides, and the last about parole revocation.
So with respect to the caseloads, we do not have a weighting system. We count misdemeanors at a certain level, and we count felonies at a certain level. And that's been what was done in a number of studies. We are looking to have a more detailed analysis of our caseload, where we've worked with the law firm to develop that, and we will continue to work with them to develop a more detailed analysis to give a better weighting to the caseload. And with respect to parole revocation matters only arise if the person is found in violation by the parole officer. So we don't advise them about going into parole, because they're released on parole, so they're released to the community with certain conditions. If they violate one of those conditions, then they would be arrested and charged with a violation of parole, and we would then represent them. We don't handle them otherwise.
Thank you. Okay, this has been a great session, and all of these issues, particularly about structure, quality, and the rest of the issues will be discussed today, will be discussed in further detail in the breakout session. So I know all of you will get a chance to talk about them in more detail.